How do expenses or hard costs work in Illinois personal injury cases? Hi, I'm Josh Rohrscheib. I'm a personal injury lawyer in Central Illinois. And in this video, I'd like to talk to you about costs, or the expenses or the money that a law firm has to spend on your behalf to advance the case for you. Now, it's important to keep in mind that costs differ from fees. Fees are what you pay your lawyer for their time or for the services they provide in handling your case for you. So the fees and costs are separate, and they will be treated separately in your contract with the law firm. I would like to mention Illinois personal injury cases are usually handled on what's called a contingency fee basis. And again, this speaks to how the lawyer is paid for their time. And contingency fee cases in Illinois should always be put in writing, in a written engagement agreement, contract, representation agreement, whatever you call it. The terms should be put in writing. And it's important you look at those terms and that you understand how those terms lay out the responsibility for costs or the hard expenses that are used to advance your case. So what are the common ways that costs are treated? So probably the most common way is that law firms who handle personal injury cases agree to pay the costs up front, but to be repaid the costs at the end of the case out of a successful settlement on your behalf. And then if there is no recovery on your behalf, then the law firm would have a right to be reimbursed by the client. And that's something to be very careful about, because the costs involved in bringing your case all the way to a trial could be really substantial. So a second way that firms handle costs, which is really more attractive to the client, all else being equal, is for the firm to advance all of the costs. And then at the end of the case, if they recover money for the client, they're reimbursed their costs. And if they do not recover money for the client, the law firm covers those costs. So the client isn't out anything for hiring the law firm to handle the case for them. And they have no liability. They don't owe the law firm any money when the law firm wasn't successful in their case. A third way that we see in some cases, it isn't very common, but in some cases it could be set up this way. Sometimes a law firm may ask the client to contribute to the costs, either to pay all the costs up front or to put some funds in retainer to help with the costs. So some firms may ask the client to help pay for the costs up front instead of advancing all the costs for the client. Now that's fairly uncommon, and that may be in a case where it's obvious the client has the ability to pay those costs, or it may be in a case that's a lot more questionable, so the law firm isn't as comfortable advancing the costs. But those are the three most common ways. And perhaps the biggest difference in the first two ways is whether or not, if there is no recovery, if the client is liable to the law firm to repay the costs. So that's something that we'd encourage you to pay close attention to in your contract. There's one other issue that we're seeing from time to time in personal injury contracts, and that is some law firms will advance the costs for you, and they will have to borrow money because they've got lots of clients that they're advancing costs for. And sometimes in the fee agreement, the law firm will say, you know, we're going to be borrowing money from a bank to cover the costs in your case. We'll have to pay interest on the money we borrow, and we can also charge you for that interest at the end of the case. So that isn't wildly uncommon. I suspect in time we'll see it more and more often, but it's just something you should be aware of, because the interest rates could be higher than you might guess. The case could go on for a few years, and it could really be a substantial amount of your money that you'll be paying if you agree to that term. So just some things to be on the lookout for. And again, it's very important to make sure that your fee agreement with your injury law firm is in writing, and that there's a clear understanding about how costs will be handled and whether or not you will have any liability to the law firm or any responsibility to the law firm to pay for your costs if they're not successful in recovering money on your behalf. We typically handle cases for injury clients by advancing all the costs on their behalf, and in most cases, I will not require the person to reimburse us for our costs if we're not able to recover for them. We don't do that in 100% of our cases, but in most of our cases. So if you have any questions about personal injury cases in Illinois, I hope you will consider reaching out to us. We'll be happy to give you a free consultation. And hey, I hope this information is helpful, and I appreciate you taking the time to watch this video. Thank you.